Hello, everyone. My name is Jack Tudor, and I'm the Chief Judge in the 17th Judicial Circuit, which serves Broward County. Today, I'd like to give you a brief overview of risk protection orders in Florida. In April of 2018, as a result of the shooting at Marjory Stoneman Douglas High School, the Florida legislature enacted a number of new laws, one of which was the risk protection statute. In a broad overview, the statute permits a law enforcement officer or agency to petition a circuit court judge for a risk protection order. The petition must be under oath and allege that the respondent poses an imminent danger to himself, herself, or others. The circuit court judge has to hold a hearing to determine if reasonable cause exists to enter a temporary risk protection order. The hearing has to be held with the petitioning police officer or agency within 24 hours after the petition is filed. If the judge enters the temporary risk protection order and the petition is served on the respondent, he is asked to surrender any weapons, ammunition, or concealed weapons permit. The order by the judge sets a final hearing on the petition no later than 15 days after the temporary order is entered. Until the final hearing is held, the respondent is prohibited from owning, possessing, or attempting to own or possess a firearm or ammunition. At the final hearing, the petitioning law enforcement agency must prove, by clear and convincing evidence, the allegations set out in the petition. Both sides can present evidence as in any trial. If proven, the risk protection order can be entered for up to 12 months and would prohibit the respondent from owning, possessing, or attempt to own or possess any firearm or ammunition. If the court issues a risk protection order, it must inform the respondent that he or she is entitled to request a hearing to vacate that order. Further, all RPOs are reported to the National Crime Information Center and stay in that database for as long as the injunction is in place. There are both criminal and civil penalties available to the court for non-compliance with an RPO. Those include charging a person who has a firearm while the subject of an RPO with a third-degree felony, punishable up to 5 years. If the risk protection order is denied, any weapons or ammunition seized must be returned to the respondent. Risk protection orders are particularly tricky with juveniles. There is no provision in the statute to appoint an attorney, as these are considered civil proceedings. Further, many circuits reveal the name of the juvenile and do not afford protections he or she may be entitled to in the juvenile court. The petitions primarily that have been filed fall into only a few areas. All of the petitions have a common thread, which is the respondent is threatening himself or others, or has committed an act of violence against another and continues to pose a threat to such person, or has a significant mental health issue which results in that person threatening himself or others. In my opinion, after 12 months of enactment, the statute seems to be effectively carrying out its purpose, which is to prohibit persons threatening others or having caused harm to others or themselves from owning, possessing, or attempting to own or possess a firearm or ammunition.